We have an update in a sick case of a babysitter accused of sexually assaulting a toddler. Here is Victoria Cranmer in a New Jersey courtroom this week. Investigators say she allegedly kept a video of the awful incident on her phone, and she was laughing as she took it. I will warn you, the details of this story are not easy to hear, and yet there are now questions about whether
A babysitter sat in a New Jersey courtroom accused of recording herself laughing while a toddler touched her inappropriately. And when her public defender stood up to defend her, she didn't argue the video didn't exist. She argued that children just do that. They touch things. They're curious. They don't understand personal space. That was her defense, in open court, for the world to hear. Picture this, a 14-second video on a phone, saved to Snapchat, discovered by a woman who had just kicked the babysitter out of her house. The video shows a 2-year-old boy standing next to a naked woman on a toilet.
One of those videos was a 14-second video clip taken while inside the bathroom at the child's residence. The video showed the defendant naked from at least the waist down, sitting on the toilet, while the 2-year-old juvenile stood next to the defendant.
Prosecutors say Cranmer is heard on this video laughing as the young boy, frankly a toddler, touched her private.
The woman is laughing. The boy's hand is on her. The woman does nothing to stop it. She films it. She saves it. And when the case goes to court, the defense says it was all just a misunderstanding. That's the image that defines this case. A video so disturbing that the judge called it bizarre. A defense so tone-deaf that it sparked outrage.
A judge overseeing this case of this babysitter now in jail for just a horrific crime. You just can't imagine it if all of this is true. The judge called the case troubling at a last court hearing. And based on what we've been told about this case, troubling.
And a legal system now debating whether a plea deal is even possible. Before we go deeper into what the evidence actually shows, make sure you're subscribed to Shadow Jury Archives. Because we don't just cover the story, we follow the facts. The investigation began on May 20th.
And that is when the New Jersey Division of Child Protection and Permanency contacted police in Little Egg Harbor, New Jersey, which they're a group that investigates concerns about child abuse and neglect in New Jersey. A woman is identified in court records only as Miss P, and she was the one who allegedly came forward claiming that she found this very disturbing video on Victoria Cranmer's phone, specifically.
When a woman identified only as Miss P contacted the New Jersey Division of Child Protection and Permanency, she had found something on a phone she'd given as a birthday present to her former roommate. A phone she'd asked for back when the roommate was asked to leave.
She said she wanted the phone back. And when she got the phone back, that phone did not have a passcode on it. So court documents show Miss P goes into the phone and finds the kind of video saved to Cranmer's Snapchat, allegedly, that would forever be seared into your mind.
The roommate was Victoria Cranmer, a 25-year-old with a traumatic childhood and a DUI on her record. Miss P said she opened the phone and found a video saved to Snapchat. She said she immediately knew it was Cranmer because of Cranmer's unique tattoos. She said she knew where the video was shot, a house where Cranmer occasionally babysat. The video showed Cranmer, naked from the waist down, sitting on a toilet. A 2-year-old boy stood next to her, his hand touching her. Cranmer laughed. The boy was still in diapers. 14 seconds. That's the entire length of the video. 14 seconds that prosecutors say show sexual assault, child endangerment, and manufacturing child sexual abuse material. 14 seconds that a public defender then described as a child being curious, a child lacking personal space awareness, a child doing what children do. Children often have little appreciation for personal space or privacy.
Quote, anyone who has spent time caring for young children understands that children often have little appreciation for personal space or privacy. Young children routinely follow parents or caregivers into bathrooms, touch things, ask questions, are curious and fail to recognize ordinary social.
The public defender said, young children routinely follow parents or caregivers into bathrooms, touch things, ask questions, are curious, and fail to recognize ordinary social boundaries. She also argued that adults often record funny or spontaneous moments because they're memorable. She said the video had been blown out of proportion. A child touched a babysitter's private area. The babysitter filmed it, laughing, and the defense called it curious. The judge didn't agree. I find it troubling, the judge said. There wasn't any attempt to stop the child from touching her in the pubic area. The judge called it bizarre.
Not bizarre because the child went with Cranmer into the bathroom. The judge said it was bizarre because Cranmer allegedly did nothing to stop the toddler from touching her private area. And she reportedly laughed, she giggled, and recorded this video, then saved it. The judge said this, quote,
Not bizarre because the child went into the bathroom with Cranmer, but bizarre because Cranmer did nothing to stop it.
Yeah, and from the previous court hearing, you saw the defense kind of trying to make this argument of like, oh, kids play around. And then, the judge even said like,
she laughed, she giggled, she recorded it, she saved it. And then she did nothing. The judge's words hung in the courtroom like a verdict of their own. The child was 2. The adult was 25. The video was on her phone, and she laughed. Children touch things. That was the defense. That's the refrain that will follow this case. Children touch things. Children are curious. But curious children don't film themselves. Curious children don't save the video. Curious children don't laugh. And curious children aren't the ones sitting in jail facing decades in prison. So ask yourself this. If the defense's best argument is that a toddler didn't know better, what exactly is the jury supposed to believe about the adult who did? Cranmer has been in the Ocean County Jail since her arrest on July 8th. She's been held without bond.
Doesn't seem like she has an extensive criminal history. There's like a DUI in 2023. She's apparently had, just based off court records, some mental.
A decision that surprised even a former sex crimes prosecutor who joined the case as a commentator.
A little bit, Chris. I mean, I've seen cases with a lot more alleged child exploitative material that was on devices. It's pretty indisputable that it's on there and what it is. And those folks were out on bond. And so
he said he's seen cases with more explicit material where defendants were released. But those cases didn't involve direct contact with a toddler.
Participant in what the government may be considering child sex assault. That ups the ante a little bit, and so I can understand why a judge was more.
Those cases didn't involve a 14-second video of the defendant participating in the act. The judge's decision to hold her without bond speaks volumes about how this video is being interpreted, not as a child being curious, but as something far darker. The charges Cranmer faces are staggering sexual assault on a child, endangering the welfare of a child, manufacturing child sexual abuse material, and possession of child sex abuse material. If convicted, she faces 5 to 10 years on the sexual assault charge alone.
She'll have to register as a sex offender for life, according to New Jersey law. She is also facing a stiff prison sentence possibility. The sex assault and manufacturing CSAM charges both carry 5 to 10 year prison terms. Her other charges would carry up to
another 5 to 10 on the manufacturing charge, and up to 5 years on the remaining counts. She would be required to register as a sex offender for life. And yet, at a brief court hearing this week,
Mr. King, have you had a chance to receive discovery?
Judge, I've not received any discovery yet.
No offer at this time, Judge. Certainly, I would ask that we bring this back for another EDC. The state does anticipate extending a
prosecutors mentioned the possibility of a plea deal.
Or even that there might be a plea deal if no such plea deal was being considered. So what it tells me is that they're at least contemplating, hey, is there a way?
No offer has been made yet, they said, but they anticipate extending one. The defense attorney hadn't even received discovery yet, but the conversation had already begun. A plea deal in a case this disturbing, that's the ticking clock at the center of this trial, a legal system processing the unthinkable, trying to find a resolution that satisfies justice without forcing a jury to watch a 14-second video that will sear itself into their minds. The mother of the child, identified as Miss H in court records.
And she said that she knew something was wrong. She didn't even know about the video at that point, but she noticed something was wrong because her son stopped liking the bath, and he was just acting differently after he spent time with Cranmer. Now, Cranmer allegedly bathed with the boy herself.
Said she knew something was wrong. She didn't know about the video yet, but her son had stopped liking baths. He was acting differently after spending time with Cranmer. She sensed it before she saw it, the shift in her child's behavior that parents learn to recognize when something is deeply wrong. The child was 2. He couldn't tell her what happened. He could only show her, through his fear of water and his changed demeanor, that something had gone terribly wrong. Children touch things. That was the defense. But children who are hurt don't just touch. They stop bathing. They stop trusting. They change in ways that parents recognize even when they don't yet know why. The public court record for this case is available through the New Jersey Judiciary's public access system. Pull the complaint. Read the judge's statements. Count how many times the defense's argument uses the word curious to describe what happened. Then answer this in the comments. When a defense attorney argues that a toddler's curiosity excuses an adult's actions, who bears the cost of that argument? The child, the accused, or the integrity of the justice system itself? If this breakdown helped you see the case differently, like this video, share it with someone following this trial, and subscribe to Shadow Jury Archives with notifications on, because we'll be back inside the courtroom with the next moment that matters.